and welcome to this video program, Immigration Tribunal Guide for the Appellants. My name is Barrister Asad Maqsood. I'm a barrister and I specialize in immigration and asylum law. I'll take you to the program slides now where we can make a start. This short program is an Immigration Tribunal user guide for the appellants. This video is made to assist people who are going to attend main hearings in the First-tier Tribunal, Immigration and Asylum Chamber as a witness or appellant, especially if they're going to do this for the first time. In this video, I'll explain the process and procedure of appeal hearings before the Immigration First-tier Tribunal. The information that I will provide here is intended to assist the tribunal users who appeal immigration decisions. They are called the appellants. The video is aimed at providing information to the appellants who are legally represented on the day of the hearing by an advocate, normally a barrister, but people who are unrepresented may also benefit from this program. In terms of program contents, it consists of the information that the appellant's lawyers or barristers provide or should provide before the hearing in order to familiarise the appellants or witnesses with the hearing process. Some of the topics covered in the guidance include essential paperwork and dress code, arriving at the tribunal and adjournments, barrister conference and case listing, vulnerable witnesses, hearing room arrangement, pre-hearing discussions between the lawyers, the way to use an interpreter and speaking in court effectively, the order of evidence and witness familiarization, video or remote hearings, and hearing do's and don'ts generally. It also contains the answers to some of the most common questions asked by the appellants from their lawyers or barristers about the day of the hearing. I'll first give some guidance about the paperwork for the hearing, and in that, first the appellant's bundle. Your lawyers would have sent a bundle of papers to tribunal already before the hearing. These papers are called the appellant's bundle. This would include or should include all the documents that you want the judge to consider as a part of your case. The tribunal usually directs for the appellant's bundle to be provided sometime before the date of hearing. If the appellant's bundle is provided late, the tribunal may ask the reason for such delay, or worse, may adjourn the case in extreme cases. The bundle should contain relevant papers only. There is no need to provide irrelevant papers in the bundle. Your lawyers would advise you on what papers are relevant to include in the bundle. Some papers such as appeal form and grounds, witness statements and any previous decisions about the same appellant would almost always be relevant. Your bundle must be page numbered. If you choose to provide photos in the bundle, always mention with each photo who appears in the photo, when the photo was taken and where it was taken. The next important set of papers is the respondent's bundle. Appeals in the tribunal are made against the decisions of the entry clearance officers or Secretary of State for the Home Department. They are called the respondent in the appeal. Normally, you would also have papers provided from the respondent's side as part of their case. That set of papers is called the respondent's bundle. If your lawyers have instructed a barrister for your hearing, they would have sent the same two bundles to your barrister in advance, so your barrister would be aware of the hearing paperwork before the hearing. You must also familiarise yourself with these papers and all the information included in these two bundles. By the time your lawyers prepare your bundle, they would have received the respondent's bundle as well. There is no need to repeat the documents in the appellant's bundle which have already been provided in the respondent's bundle. Another important point is the timeliness in providing the paperwork to the tribunal and the respondent from your side. You normally only rely on papers before the tribunal that you have provided in your bundle beforehand. However, if exceptionally you're relying on additional documents, then send them to the tribunal and the respondent as soon as possible. And if there is any additional evidence still not included in the bundle that should have been included in the bundle, and you want to rely upon such additional evidence, you should bring that additional evidence with you on the day of the hearing, and you must bring at least 3 copies of each document with you. If it is a CVP hearing, then you should email these to your lawyers as soon as you are able to do so, so that a copy may be forwarded to the respondent and the tribunal. It is important to know how to use the bundles during the hearing. You must have an extra unmarked copy of your bundle and that of the respondent with you, which is to be used by yourself and your witnesses during the hearing when you or the witnesses are giving evidence. If it's a video hearing, or what the tribunal calls a CVP hearing, and you're using an electronic copy of the bundles, then you should have ideally a separate screen for using the bundles and a separate screen that you are using for the video hearing itself. There is also something important to bear in mind in terms of what the limits of the tribunal's role are in terms of third-party verification. The judge will not make phone calls to third parties in order to verify the evidence that you have provided, so you should try your best to provide the best available evidence at your disposal in order to prove your case. If there is a need to provide video and audio evidence in support of your papers as a part of your bundle, then there are certain things to bear in mind. You will normally have to make your own arrangements for playing the recording in the hearing room. You can do so by bringing the audio or video player with you. You will have to make arrangements with the tribunal in advance. It is a good idea to provide transcripts of the recordings in the bundle in advance if you are relying upon video or audio evidence. It is sometimes the case in the tribunal papers that there are papers that are not in English. If you are relying on documents before the tribunal which are in a language other than English, then you must provide certified translated copies of the documents. The tribunal cannot take into account documents that are not in English. The tribunal interpreters cannot be used for translating such documents. You are normally not permitted to send any evidence to the judge after the hearing. In terms of original documents, it is useful to bear in mind that you are normally expected to be in the possession of the original documents that you should have. If you have some or all of the originals of the papers with you that are in both bundles, then you should have them with you on the day of the hearing. The judge or the respondent's representative, called the presenting officer, might want to look at the originals, or your barrister might want to show it to them. The originals were not always checked previously, and it's even less likely to be the case for video hearings, but depending on context, sometimes an original document can become highly relevant. For example, sometimes the photocopy of the documents in the bundle would not be clear, especially if the document is a photograph and is black and white. You must therefore locate the originals. You must not assume that if the originals were provided to your lawyers or to the respondent in past, then they would be available on the day of the hearing and they will be provided by the presenting officer. You must locate them in advance and make arrangements for them to be made available on the day. If originals are with the respondent, then your lawyers should make a request in advance to the respondent to produce the originals on the day of the hearing where this is necessary. It's advisable for the witnesses to have their photo IDs with them when they attend, although they are not always checked, but it's a good idea to have them nevertheless. In terms of dress code and in terms of what to wear on the day, whilst there is no dress code for the appellants or witnesses, it's always a good idea to look smart on the day of the hearing if possible. On arriving for the hearing or joining the video hearing, I'd say arrive or join early. Sometimes you can't join the CVP link before the allocated time, but as far as being listed in person is concerned, you should try to reach the tribunal 1 hour before the hearing time. This is so that there is enough time for going through the security, for signing in on reception, and for speaking to your barrister about your case. For the purposes of the consultation with your barrister, conference room facilities are limited at the tribunal. You might have to speak to your barrister in tribunal corridors or waiting area if no conference room is available. As far as the solicitor's attendance is concerned, where your lawyers or solicitors have instructed a barrister to represent you in your appeal, the lawyers or solicitors would normally not attend the hearing in addition to your barrister. If there is a CVP hearing listed, you would normally have your conference with your barrister on phone before the hearing and should join the link at the given time. If something unexpected happens on the day of the hearing, then there are certain things to bear in mind if that impacts your ability to attend the hearing. Adjournments is the word used for delaying the appeal for a later date. Where it turns out that the appeal cannot proceed on the hearing date for a reason, the appellant must make the adjournment application as soon as possible, explaining the reasons for the delay or adjournment. It is, however, not always possible to make adjournment application in advance of the day of the hearing. For example, in a case of an emergency on the day of the hearing, such as due to the appellant's health or that of a family member or witness. If it's a medical emergency on the day of the hearing, the appellant or the family member must, where possible, send to their lawyers or barrister the medical evidence. It will not always be possible to provide medical report, in the absence of which any evidence can be provided to show that the appellant or the family member or the witness, whatever the case may be, is dealing with a medical or other emergency, as the case may be. It will normally not be enough to simply inform the barrister on phone that the appellant cannot come. As far as the pre-hearing conference with the barrister is concerned, a conference with the barrister before the hearing is an opportunity for you to ask any questions about the hearing process and the issues in the case. It is, however, not permissible for the barrister to coach you on your evidence. A barrister cannot tell you what you should say in answer to a question or how you should express yourself. This video contains almost all the things that the barrister is likely to talk to you about in the conference before the hearing on the day. Normally your case will be listed in one of the hearing rooms for hearing at 10 a.m. or a video hearing room, as the case may be, at 10 o'clock. If your case is listed for hearing at 10 a.m., there will normally be one or more other cases listed in the same hearing room. All cases in one room would be normally listed before the same judge and the same presenting officer, all listed usually at 10 o'clock, unless specified otherwise. If listed at 10 a.m., there is no guarantee that you will be heard first. That is, even if you appear first on the list outside the door or the main notice board or on the list online. The judge will decide the order in which he or she will hear the case, and your barrister will keep you informed on when the hearing will start. If for some pressing need on the day you want to be heard first, you should tell your barrister your reason. This way, a request may be made to the judge on that basis. It is normally appropriate for appellants with children or vulnerabilities to be heard first, so that they don't have to wait longer on the day of the hearing. It is therefore a good idea to keep the whole day free just in case. Sometimes you would be listed for a hearing on what is called a float or reserved list. Being on float or reserved list means that your case has not been allocated to a judge. Once a judge becomes free on the day, your file will be passed on to them at that point. This means that you may have to wait for a tribunal judge to become available before you can be heard. If your case is listed on a float or reserved list, this means that the judge and the presenting officer will read your papers once your case is allocated to them on the day of the hearing. Some cases are not suitable for float list, and if your case is one of them, your lawyers should write to the tribunal in advance. In their request, they can explain why the case is not suitable for float list so that it is not listed as such on the day. Most of the times, the cases on float list get heard on the day. However, sometimes some cases are adjourned for a later date for lack of judicial time. In terms of assessing the vulnerability of witnesses, it is the responsibility of your lawyers to identify if the appellant or one of the witnesses in the case is a vulnerable person. The tribunal judge will have to consider this as a preliminary matter where it is raised by the appellant's lawyer or barrister or is apparent otherwise. Your barrister might also consider that the appellant or one of the witnesses is a vulnerable person. There are many factors that can contribute towards making someone vulnerable. They include, but are not limited to, age. For example, someone is too young or too old, being a victim of modern slavery, victim of trafficking, family conflicts or separation, fear of children being taken out of school, fear of sudden deportation, mental health issues, physical health issues, and traumas, etc. If for one or more of these or other factors a witness is considered vulnerable, your barrister will speak to the judge about this and make the appropriate arrangements on the day so that in progressing the case, the relevant vulnerability may be taken into account. You must switch off your mobile phone or put it on silent mode before you enter the hearing room or join the video link. Using phone for calls or texts is not allowed in hearing room unless you are using it for texting your barrister in video hearing after you have given your evidence or before you have started to give your evidence. Taking photos or recordings in tribunal buildings is also not allowed. If joining by video, the recording of that is not allowed by you, but you can make your notes by writing or typing. If joining by video, then it is recommended that you join by a computer or tablet as opposed to a mobile phone, given that you will have a bigger screen or on computer or tablet and a much smaller screen on mobile phone. Hearing rooms in tribunal buildings are normally small, unlike what you see on TV. Your barrister will show you where to sit when it's your turn as far as in-person hearings are concerned. You would be sitting facing the judge, and you would normally have the presenting officer and your barrister sitting to your right and left facing each other. If there is an interpreter, he or she will sit right next to you facing the judge. You will have to stand up when the judge comes in the room and leaves the room, unless there is a reason why you cannot do so, for example, because of a disability or physical impairment. During the rest of the proceedings, including during your evidence, you would remain seated. You obviously do not have to stand up in a video or CVP hearing. By way of greeting, it's not appropriate to seek to shake hands with the presenting officer or the judge. You will have to take head coverings off in the hearing room unless there is a good reason why you cannot do so. For example, you wear it for a religious reason, etc. Immigration appeals are usually heard by a single immigration judge who is a legally qualified person. The judge is independent of the respondent. If you need to address the judge, you will call the judge sir or madam, as the case may be. An experienced immigration barrister would normally know the judge from previous hearings. Your barrister would normally not say anything about the judge from his or her previous experience with the judge to ensure that your evidence before the judge is not affected by such remarks. Sometimes your barrister will have a discussion with the presenting officer before the hearing. Presenting officers are normally the employees of the Home Office. Sometimes they are independent barristers like myself, hired by the Home Office for the day. They are not the individuals who would have made the decision under challenge. Sometimes your barrister would speak to them in advance of the hearing if there is an opportunity to do so in order to narrow down the issues. Normally such discussions do not take place in front of the appellants. However, in CVP hearings, usually the discussion, if there is any, would take place before the appellants unless the presenting officer wishes to do it otherwise. Your barrister would in any event inform you about what was discussed in such pre-hearing discussion where that is relevant. Sometimes the presenting officer would inform your barrister at that stage that the respondent wants to withdraw the decision or a particular matter raised in the decision. They would have to make withdrawal before the judge. If the respondent withdraws the whole decision, then save good reason, the judge will allow the respondent to withdraw and the appeal will become abandoned. If this happens, then the matter is back with the respondent again and there is no pending appeal. There may be instances when there is no presenting officer present on the day of the hearing. The respondent is usually represented by a presenting officer for most appeals, but sometimes there is no presenting officer in a particular hearing room on the day of the hearing. If that happens in your appeal, then the procedure will remain the same, except the fact that there will be no one from the respondent side asking you questions or making submissions on behalf of the respondent. The absence of a presenting officer does not mean that the appeal has been conceded by the respondent or that the decision has been withdrawn. The judge is still expected to assess both parties' positions and apply the law before deciding the appeal. Where there is no presenting officer, it is not for the judge to cross-examine the appellant or witnesses or ask questions on behalf of the respondent. He or she may, however, ask certain clarificatory questions in that instance. You might have friends and family members, etc., attending the tribunal to show their support who are not witnesses in your case on the day of the hearing. It's up to you whether you want them to sit at the back in the hearing room right from the start or you want them to join in later once you have given your evidence. Some people do not feel as comfortable giving evidence in front of everyone who attends with them on the day. If this is the case, you might want them to join in once you have finished giving your evidence. Cheering or clapping by your supporters is not appropriate in the tribunal. As to who will be present in the hearing room, normally in addition to yourself, your barrister, the presenting officer and judge, a court clerk might be present in the room and an interpreter if one has been booked. Normally when your case is heard, members of public unrelated to the case will not be present in the hearing room. But tribunal hearings are public hearings, which means other people can be present in the room unless the court directs that members of public be excluded from the hearing. In the absence of such direction, members of public are allowed to be present in the room. If you have a concern about it, you should speak to your lawyer in advance. You may wish to apply for a direction to remain anonymous, alternatively, which does not automatically exclude members of the public from the hearing room, but protects your identity in published court records. In certain circumstances, you may be entitled to a private hearing, where only people related to your case will be permitted to be in the room. You can discuss this with your lawyer if this is something that you want to put in place in advance. Children are not normally allowed in the hearing room. If you attend the tribunal with children, please ensure that they are accompanied by an appropriate adult, so that there is someone with the children outside of the hearing room in the waiting area at all times. In some cases, the lawyers might want a child to give evidence in the tribunal. If this is the case, the barrister would make the appropriate arrangement with the tribunal to facilitate the child's evidence. If you are giving evidence from home, please ensure that, where relevant, appropriate childcare arrangements are put in place and the children cannot hear the proceedings and cannot be heard during the hearing. Many people in tribunal hearings speak through an interpreter, as English will not be their first language. A majority of these people will not have any prior experience of speaking through an interpreter. It is important that when you speak through an interpreter, you speak slow and in small chunks so that the interpreter is able to translate your evidence fully. If you are asked another question before you have fully answered the previous question, then you must say so. You should give the full answer to the previous question before answering the next question. As far as the timing of booking an interpreter is concerned, where a request has been made in the appeal form itself, the tribunal will arrange for an interpreter of your chosen language. The request should, however, be made in the appeal form itself. If a request is only made on the day of the hearing for the first time, it is not always possible for the tribunal to arrange an interpreter on the day. Such late request may cause an adjournment if the hearing cannot proceed without an interpreter. At the same time, only ask for an interpreter if you need one, as asking for an interpreter in advance and later not using one during the hearing is a waste of court's resources and public money. These interpreters are for hearing room use only as far as their role is concerned. They would normally not assist for interpreting for a client conference with the barrister outside of the hearing room. Many people who use interpreters also have some familiarity with English language. It is important that you do not shift from your own language to English during your evidence, as this creates confusion. Sometimes, in that case, the judge will allow you to use interpreter only when you are unable to understand or express a word or phrase if you wish to give your evidence in this manner. During evidence, it is not always possible for you to notice a mistake in interpretation or translation by the interpreter. If you do notice, then you should bring that to the judge's attention or that of your barrister during the hearing. If your barrister is not familiar with the language and you have a basic understanding, but your solicitor is familiar with your language, then that is a good reason for the solicitor to attend the hearing to highlight any interpretation error to the barrister. At the start of the hearing, the judge will introduce himself or herself. Where an interpreter is booked, the judge would also ask the interpreter to speak to you by asking a question or two. This is to establish that you and the interpreter understand each other. The judge will check if all parties have the same papers before them and will ask your barrister and the presenting officer if there are any issues to deal with before the hearing can start. These are called preliminary issues. If there are no preliminary issues, the hearing will proceed to the evidence stage. When you speak in the tribunal, bear in mind that your barrister, presenting officer and the judge have to take down the note of what is being said, and the interpreter, if there is one, has to translate what you are saying. You should therefore speak slow, with appropriate pace, so that a full note is taken of what you are saying. Appellants often have to talk about matters that are very personal to them, or they often talk about traumatic experiences in past, especially in asylum appeals. It is natural to get emotional while expressing such matters. You may therefore ask for a short break any time if you feel emotional during your evidence or for any other legitimate need. You cannot speak to your own barrister or any other person during breaks while you are still giving your evidence. Although questions would normally come from your barrister and presenting officer, who would normally be sitting to your right or left, but you should address your answers to the judge. You should bear in mind that both lawyers want you to give your answer to the judge. If your supporters or other witnesses are sitting behind in the hearing room during the hearing, they must not talk while your evidence is being heard. If someone else is giving evidence in addition to yourself, then they will normally not be present in the room when you will give your evidence. They would only come in the hearing room when it's their turn to give evidence. Witnesses are not supposed to speak to one another about their evidence during the hearing in or out of hearing room. If the case is being heard on video, then the other witnesses should wait at a place where they cannot hear the evidence being given before their turn. In some video hearing cases, the respondent or the judge would expect the evidence to be given from the solicitor's office to maintain this distance while the evidence is being given. But hopefully the logistics of this would have been decided in advance of the hearing, usually in a case management hearing before the day. In tribunal hearings, you do not take an oath on holy books or formally affirm as you do in other courts. But you are, of course, expected to tell the truth. Your witness statement will contain a statement of truth confirming the contents of your evidence as true and accurate. You and your witnesses would normally give evidence before the tribunal in 3 stages. The first stage is called evidence in chief. This involves adopting your witness statement and answering open questions or supplementary questions from your own barrister. If someone wants to give oral evidence in a case, then their witness statement must be served and filed in advance. That means it must be provided to the respondent and the tribunal in advance. This is normally included in the appellant's bundle. It is for your lawyer to decide who will give oral evidence in appeal. Just because X number of witness statements are provided by your lawyers in your bundle does not mean that all of those witnesses must give oral evidence on the day. Exceptionally, in some cases, there is no need to hear any evidence from the witnesses. In almost all appeals, you would give oral evidence in support of your case, which you would have set out in your witness statement already. A witness statement is the most important document in your appeal. This is your reply to the decision under appeal. It is not possible for you to reply to the refusal letter without reading the decision letter fully or without it being read to you fully in your own language. Unless there is a good reason, it would be reckless not to respond to each relevant objection raised in the refusal letter that you do not agree with. It should be drafted by your lawyers, as your lawyers would know better the facts that are relevant to your case. But it must be drafted on your instructions only and in your own words as far as possible. You must read your witness statement once again or have it read to you in your own language before the day of the hearing. If you cannot read English, your witness statement must contain a statement of truth from the person who has read the statement to you in your own language. Although your witness statement is drafted by your lawyer, on your instructions, it must not contain legal submissions. It is a document which is intended to provide relevant factual information only. It is not an opportunity for your lawyer to make legal submissions. It should ideally be in a chronological order when setting out the relevant facts and in numbered paragraphs. It should be expressed in your own words where you speak English, or in your translated words where you used interpreter for providing evidence in your witness statement. It should state your evidence on facts and not your opinions on matters on which you are not an expert to give an opinion. Witness statement can set out medical or country of origin issues where relevant to the case, but where you rely on medical condition, there must be additional evidence from medical expert. Similarly, where you make assertion about how things usually work in your country of origin, there must be country of origin objective evidence or expert report to support your assertion. If it does not contain information on relevant, important factual matters, this may affect the credibility of your evidence. If you provide important, relevant information during your evidence only, which is not already stated in your witness statement, this normally affects the credibility of your evidence. It should ideally be prepared once the bundle is ready and has been page numbered. This is so that you may draw the reader's attention to the page number of the bundle when you are referring to a document in your witness statement. It should ideally introduce each document to the reader by expressing what a particular document is in the bundle, how you are in possession of that document if that is relevant, and what does it show, and how does that relate to your case. Since your witness statement is supposed to contain your full response to the decision under challenge, your barrister would ask you to adopt that statement before the judge. Adopting a statement means that you state your name in answer to your barrister's question, and then your date of birth, and then your address before the judge. And then you confirm that the contents of your statement are true and accurate in response to your barrister's question. A witness statement is expected to contain all the information necessary and relevant for this stage. However, your barrister might ask you some supplementary questions after you have adopted your witness statement. This is in order to complete your evidence or clarify matters within your evidence or seek an update since the date of the witness statement. Sometimes this is done to simply make you comfortable in the courtroom environment. Judges would normally be very reluctant to allow your own barrister extensive questioning at this stage. This is especially if the questions relate to new information that should have been in the witness statement but is not in the witness statement. It is therefore imperative that your witness statement contains all the relevant evidence and information. Once your barrister has asked these supplementary questions, this is the completion of the first stage of giving evidence. The second stage of your evidence is called cross-examination. This is where you will be asked questions by the presenting officer on behalf of the respondent. A presenting officer's job at this stage is to test your evidence to support the respondent's case or the respondent's position. The presenting officer can ask you leading questions. This means that the question can contain information that is contained in the bundle before the tribunal. They cannot, however, ask you misleading questions. This means their questions cannot contain information which is incorrect as per the evidence provided in the bundles before the tribunal. The presenting officer also cannot lead from information which is not contained in the bundles before the tribunal and the parties. It is therefore essential that you have read all the papers before the hearing. Your barrister cannot answer the presenting officer's questions on your behalf. Your barrister cannot stop the presenting officer from asking questions as long as questions are appropriate. Where the presenting officer asks inappropriate questions or the method is inappropriate, your barrister will intervene. In terms of general do's and don'ts at this stage, you are not expected to respond to statements made by the presenting officer. Therefore, you must wait for a question before answering it. Do not try to reply to a statement. You should not answer a question by a question. You are not expected to know everything. Do not try to guess what the answer might be. If you don't know the answer to a question, just say so. Oral evidence is not intended to be a memory test, and therefore if you do not remember a date exactly, you may say so. If you must give background explanation in your response at length to a question, then first answer the question and then mention that you are going to explain the background. This is so that you do not appear to be talking about something unrelated or, worse, appear evasive. Listen to the question carefully and only answer the question, and you do not have to repeat your witness statement, which the judge and the presenting officer will have read before the hearing. If you do not understand the question, you can ask the question to be repeated or rephrased before you answer the question. If in cross-examination you're told that you said in your statement or it's stated in your papers and you cannot fully recall what is said and the context, then you may ask that you be taken to the papers where you have referred to that matter before answering the question. If you are using the interpreter, you can ask the interpreter to read the part of the document that is being referred for you so that you can understand the question fully before answering it. If you do need a comfort break at any point during the hearing, you may draw your barrister or judge's attention to that. Once you have answered the questions from the presenting officer, this is the end of the second stage of your evidence. The third or final stage of giving evidence involves questions from your own barrister, and it is called re-examination. Where your barrister chooses to ask you questions at this stage, they will be for clarifying your evidence in cross-examination. The barrister cannot ask questions about something new at this stage which did not arise in cross-examination. The judge can also ask questions before, during, or after any of these three stages of your evidence. The judge is independent of the parties, and it is important that the judge seems impartial. This means that it is important that the judge does not appear to be taking sides with either the appellant or the respondent. Your barrister will assess whether any questions from the judge are appropriate. Once you have given your evidence, then, where relevant, your witnesses will be called one by one to give evidence in the same three stages as you would have given your evidence. Once you and any witnesses additionally have given evidence before the tribunal, the judge will hear submissions from the presenting officer first. Submissions is the word used for reasons that an advocate would give to support their client's case. Presenting officers would normally rely on the reasons given in the decision letter itself that you have appealed, which you would have read already. They may also rely on the respondent's review document if one has been provided, which you also would have read in advance. You should listen to those submissions, and you're not allowed to speak after you have given your evidence or interrupt. You may, however, keep a pen and paper with you, and if you wish to write and pass on a note to your own barrister at this stage, you may do so. If the matter is being heard remotely, you may text your barrister during the respondent's submissions if you wish to raise something with your barrister. Once the presenting officer submissions have been made, your barrister will make submissions on your behalf, replying to the respondent's submissions where appropriate. In making those submissions, your barrister will rely on the appellant's skeleton argument that will have been provided in advance, and you will have read that document already. A barrister does not need to repeat everything in the skeleton argument, as the judge will have read it already, and the submissions will expand upon matters stated in the skeleton argument. Both advocates at the end of their submissions might also make submissions about fee award. The presenting officer would sometimes seek to persuade the judge that, where appeal is allowed, the fee award of the tribunal appeal fee should not be made in favour of the appellant, and your barrister would sometimes oppose that. Exceptionally, where one party has acted unreasonably in the appeal before the tribunal, the other party can make an application for wasted costs against the other party. But that is not common in tribunals. After the end of your barrister's submissions, the judge will normally reserve the decision. This means that the decision is not given on the day, and the judge will send you the decision in writing, which usually takes a few weeks. Some judges would exceptionally indicate the outcome they propose to give, but the decision is officially issued in writing. In the absence of any clear indication by the judge on the outcome of the case, your barrister would be unable to give you any indication of the likely outcome of your case. Your barrister may not ask the judge to indicate the likely outcome of the case. Once a decision has been received from the tribunal, both parties have 14 days to challenge the tribunal's decision via permission to appeal to the upper tribunal. The barrister may, however, point out to you any concerns arising from the hearing in the post-hearing discussion or briefing after the hearing. Your barrister will also update your lawyers or solicitors about the proceedings where you have instructed the barrister through solicitors. Normally, where your lawyers have instructed a barrister for your hearing, the barrister would have no involvement in your case after the hearing unless they are required by your solicitors for further assistance. Your barrister in this case will be contactable through your solicitors. We are near the end of this video. I hope it provided you enough information to make your hearing day easier. Thank you for watching this video, and if there are any questions about the information provided, you should ask your lawyers or barrister before the hearing. I wish you all the best for your case.